Hello, everyone. So today we will be discussing a landmark decision during 2023 by the Federal Court of Australia in the case of PepsiCo Inc. versus Commissioner of Taxation. The Federal Court has ruled in favor of the Commissioner of Taxation against PepsiCo in this particular case on 30th of November 2023. The case concerned PepsiCo's royalty-free agreements with Schweppes Australia Private Limited. So the federal court ruled that PepsiCo was liable for royalty withholding tax at a rate of 5% in relation to portions of payments made under exclusive bottling agreements, which were held to be royalties, and in the alternative diverted profits tax at a rate of 40% would apply if the payments were not considered as royalty. So this decision was the first time the diverted profits tax provisions were considered by a court. PepsiCo has, however, appealed the decision. So in order to achieve a successful outcome, PepsiCo will need to succeed on both the royalty issue as well as the DPT issue. So it would be interesting to follow the further proceedings in this particular case. So coming to the facts of this particular case, PepsiCo and Stokely Van Camp had exclusive bottling arrangements with an independent Australian bottling company, Schweppes Australia Private Limited. So under this agreement, PepsiCo or SVC, which is Stokely Van Camp, agreed to sell or cause a related entity to sell beverage concentrate to SAPL for bottling and sale, and granted SAPL the right to use the Pepsi and Mountain Dew trademarks. However, no royalties were paid under the agreement, and therefore no withholding tax was deducted in Australia, neither paid. The only relevant payments made were for the purchase of the concentrate. Now, this slide, it depicts the whole entire arrangement, the facts. So during the financial years, which are the relevant years in this particular case, 2017-18 and 2018-19, the Concentrate Manufacturing Singapore Private Limited, CMSPL, a Singaporean entity and a member of the PepsiCo group, produced concentrate according to a recipe or formula provided by PepsiCo and SVC. CMSPL supplied the concentrate to PepsiCo Beverage Singapore Private Limited, an Australian entity also a member of the PepsiCo group. Now, PBS supplied concentrate to SAPL and invoiced SAPL for the concentrate that had been supplied, and SAPL paid PBS for the concentrate. And PBS further transferred the money received from SAPL to CMSPL, which we assume was as a concentrate purchase price. However, the ATO did not seem to assert that any portion of this payment was a royalty. Hence, PBS retained only a small margin. Now, the key issues before the Commissioner of Taxation and what the Commissioner of Taxation, what he raised, the key issues. So the Commissioner of Taxation proclaimed that PepsiCo was liable for royalty withholding tax under the provisions of the Income Tax Assessment Act 1936, which are governed by Article 12 of the Double Tax Agreement between Australia and the USA. Further, the Commissioner promulgated a diverted profits tax assessment against PepsiCo, levying a 40% punitive tax on the contested royalties. The DPT aims to ensure that taxes paid accurately reflect the economic substance of the significant global entities' activities in Australia, and to prevent the shifting of profits overseas through arrangements with related parties. Now, coming to the court's ruling. So the federal court affirmed that royalties were inherent in SAPL's payments for concentrate essential for beverage production, branding, and IP rights. PepsiCo's global brand strength made it unlikely to license without compensation, supported by similar agreements. A royalty rate was applied, totaling Australian dollars 3.6 million in royalty, withholding tax liabilities. Under the US Australia double tax agreement, payments to PBS were deemed income for PepsiCo and SVC. Now, PepsiCo and SVC were considered beneficially entitled to the payments as parties to the agreements, and the nomination of PBS as seller was viewed as a payment direction, not altering income derivation by PepsiCo and SVC. So, without royalty withholding tax, it was held that diverted profits tax provision, which is a 40% penalty rate, would apply due to the contrived tax benefit. So now coming to the key takeaways of this federal court ruling by the Australian Federal Court. So essentially a few points I've put on the slide. Scrutiny of royalty-free arrangements. So the case further emphasizes the Australian Tax Office's ongoing focus on cross-border intangible arrangements where royalty withholding tax has not been paid, including where licenses are granted, and to express royalty, and no express royalty is payable. Multinational entities operating in Australia under similar arrangements may face increased scrutiny. The ATO has also released a draft taxation ruling, which is income tax, royalties, character of payments in respect of software and intellectual property rights, which reflects its current draft views on whether payments made in respect of software and intellectual property rights will be a royalty. So apparently the court adopted a broader approach to characterization of royalties in this particular case. In the previous case law in IBM and Task Technology had emphasized that in determining whether payments made are characterized as royalties, Australian courts have interpreted the rights and obligations under the relevant agreement, as the agreement will determine whether the payments are for the right or use of software. However, the decision of the federal court indicates that in considering whether a payment constitutes a royalty, it is necessary to consider the characterization of the relevant payments and the terms of the relevant agreements in their business and commercial context. Now, coming to the point of diverted profits tax, the federal court's decision, it sheds some light on the application of the DPT provisions. It confirms that the principal purpose test within the DPT provisions is a lower bar compared to the dominant purpose test within the general anti-avoidance provisions. The federal court confirmed that the meaning of principal purpose is a purpose that is a prominent, leading, or main purpose, of which there can be more than one, but need not be the dominant purpose. So these were a few key takeaways from this particular ruling, and I would be soon uploading a few more videos on a few more international tax rulings of 2023. This would help you to even prepare for the ADIT exam, which is upcoming in June 2024. Thank you so much for viewing. If you like my videos, please do like and subscribe to my channel. Thank you.